It is quite chilly right here in Nairobi County, some 10 degrees Celsius. Tunakunywa kahawa yetu moto hapa vizuri. I hope back at home, wherever you're watching us from, how the weather is looking like. But don't worry, we're going to be making it as hot as is possible just for you this particular morning. Welcome to Morning Cafe. If it is your first time right here, every single Thursday, we give you law tips, some legal tips on law matters, helping you understand the legal tips around you where you live, the kind of things that happen. And you maybe really need a lawyer and you're wondering, how do I go around this? The conversation that you're going to be having today is a conversation you were having last week but one, and the number of callers that we had said, tafadhali, rudieni hii conversation, have a part 2 of this so that we understand it fully. Intermeddling with the property of the deceased. You might have gotten yourself into this, or you're actually thinking about it, but don't worry, we're going to be having a lawyer to help us understand this. Advocate Paul Mashari, he was with us last week but one, and he's also going to be explaining this to us. You can always be part of this conversation, 22047. That is our SMS number. Nitakuwa naangalia SMS zenu tukiendelea. 0793-267-279 is our WhatsApp number. Those numbers should be just below your screens. You can also call us, anza kuweka credit sahi kwa simu. 0795-045-864. Utupigie simu, utuambie uko wapi and what your question is, your feedback is concerning this particular conversation. Intermeddling with property of the deceased. We'll be getting a definition of what intermeddling is. Paul Mashari, welcome once more.
Thank you.
Naona ulipata memo yangu ya kuvaa 3-piece.
Of course I had to.
Mimi sijapata yes, the pocket square. But anyway,
yes.
I hope the weather is fantastic for you.
A bit chilly though, but
yes,
everything is okay.
Fantastic.
Yes.
So today we definitely have new viewers watching us.
Yes.
This morning we also have viewers who were with us last week but one. So for the benefit of these new viewers, help us understand what, according to the Constitution, according to the law, what intermeddling with the property of the deceased even means. Is it criminal?
Thank you. And as we said, and those who are joining us for very first time, last week but one, we attempted to give a breath to what the law may mean by when we're talking about intermeddling. And we said, the law we have now as it is, there is no definitive provision as to what amounts to intermeddling. What the law prescribes is a penalty for that person who intermeddles. But through the court decisions, what we call the court precedents, the courts have attempted to give a definition as to what may be termed as intermeddling. And by, as we will discuss as we go forward, there is an attempt by introduction of a bill in the Senate by Senator Veronica Maina to try and attempt to define what intermeddling is. Now, the focus we can have today is to look at what has the court said as what intermeddling is. In essence, the courts have in more occasion held that intermeddling is dealing with the property of a deceased without the authority of court. When you're talking about dealing, what are we talking about? We are saying, one, when somebody dies, if you do not have permission of the court, either as an administrator or an executor, anything you do with the estate of a deceased person, you are intermeddling with it. These are some of the things that may include intermeddling. One, selling the property of a deceased person, leasing the property of a deceased person, or leasing out. And then there is also apportioning the property of a deceased person. There is also charging the property of a deceased person, subdividing the property of a deceased person.
So charging is...
Charging, this is where you take the... No, you go to the bank, they give you loan, and you give them the documentation for such a property, attempting to convert the property as yours. And also, there is also a very unique aspect brought by the bill, as we shall be discussing, ejecting a spouse from the property of a deceased person has now been defined as a part of intermeddling. So the definitions we are giving, these are not defined in the Act. These are definitions that the court, in holding one to be intermeddling, have given, so that then they are held culpable to the offense of intermeddling, where we said the fine is 10,000 shillings of our imprisonment for 1 year or both.
Okay.
It depends. The court can give either or both.
Right.
It is at the discretion of the court to punish the person who has intermeddled accordingly. Yes.
I remember last week but one kuna koda alisema itakuwa vizuri tukimix lugha, ndio nimekumbuka sasa. So I think even as we continue,
yes,
and you watu pale nyumbani waelewe maneno ya sheria, tunaweza mix hii lugha. And speaking of which, so kwa hiyo bili unaongelelea ya Veronica Mainika, the Senate, it's dated, I have it here, it's dated the 12th of April 2023, and according to the bill yenye inaelezea what intermeddling is, umeelezea tu vizuri: taking possession of, disposing of, charging, receiving, hapo kwa receiving ndio nataka so tueleze, distributing, leasing or using property of a deceased without authority under this act or any other applicable law. Hizi zingine umeelezea in a sense that I as Nyeringita nimeenda nikauza, lease, nikaenda kwa bank, I know, I have knowledge that e property ni a deceased person. Let's talk about receiving, because now the other party, the third party mtu nauzia, nikuje kwako nikwambie Masharia, kuna maguta mali nimepata mali Thika ni mzuri. You have no idea that this property that I'm selling to you is of a deceased person. Why does this bill, do you first of all agree that you as Masharia mwenye nakuzia pia wewe, you should also go 12 months kwa jail and you had no idea?
Sababu ya kuleta kile kipengele cha kupokea, yawezekana katika ununuzi wa mali, ununuzi wa shamba, ni wajibu wa yule mtu ambaye ananunua afanye utafiti wake kwa kisha kwamba lile shamba ambalo analipata halina makosa yoyote.
Yeah, what we call due diligence.
Due diligence kwa Kiingereza. So it means katika ni wajibu wa mtu ambaye ananunua ama ambaye anapokea, amuulize anayemuuzia, who is the owner of the property you are selling to me? Kando na hayo, anafaa kufanya kitu inaitwa search. When you do a search, utapata ni nani anaye idhini ya kupatia ama kushughulika na the property in question. Japo utaona the search indicates somebody else, you may also want to inquire, huyu mtu ako uhai ama amefariki. Kwa sababu katika kufanya kosa, kuna tuseme kwa mfano unauza, japo utakuwa umekosea kwa kuuza, pia yule ambaye anapokea pia ako na makosa, kwa sababu it is within his or her powers to do a due diligence to ensure that whatever they are receiving ni kitu ambacho hakijahusika katika kufanya mabaya. Ningetaka tuelewe in context. For example, if somebody is arrested with stolen goods, hautasema I bought and I paid the consideration. The fact that umepatikana na mali ambayo kihalali haifai kuwa katika umiliki wako, uko mmoja wapo wa wale watu ambao walihusika to defraud the owner. That's why the issue of receiving, because then it would be I can say, because I want to defraud the rest, they are of the same transaction. Yes. And you see, when we are understanding katika kuelewa the crime, kuna wale watu tunaitanga the principal offenders.
Okay.
Kuna wale watu wamehusika kiukweli na kuna wale watu wamesaidia katika kufanya uhalifu. Sheria haiwaachi kando. The law deals with all of them. So whether you are the perpetrator or whether you are the aider or whether you are somebody who assisted in a commission of a crime, action will be taken against you depending on the magnitude and the degree of your participation. That's why sheria inasema hata yule ambaye atapokea amefanya makosa ya intermeddling. Katika ile sheria ambayo imepelekwa pale bunge ili kupigwa msasa na itakapopitishwa, it will be a law that whoever receives also participates in intermeddling with the property of a deceased person. Yes.
Inamaanisha sheria hata ukienda mbele ya court, sheria does not, court itakwambia hakuna ignorance hapo.
Hiyo hata court, the court does not need to tell you that usipojua sheria haujafanya makosa. Ignorance of law is no defense. So wezi enda kuambia mahakama sikujua ni makosa, hivyo basi nikafanya. Yes. Okay. What happens if you did not know? As a mitigation, you'll tell the court, I am a first offender. I have never done it before, and I promise not to do it again. So in that, the court may be lenient to you in terms of the penalty it will impose. But the fact is, whether you know or you do not know, the law is applicable to you.
Right. And speaking of ndio usiseme hukuna jua, we're going to be having some graphics of some of these laws and sections of the Law of Succession Act, the Act itself, tuangalie what some of these things are saying. To section 45, yes. We'll also be looking at also roles and responsibilities like in a testate versus testate, 82, 83, 84. Director, tukipata hizo graphics you can inform me so that we also analyze ndio mtoke nyumbani elewe what this really means as well. Remember, you can always be part of this conversation. As Wakili says, fine ni about...
the law is at now is 10,000 shillings or imprisonment for 12 months or both.
Yes, so you definitely want to be part of this. 22047 is our SMS number. 0793267279 is our WhatsApp. 0793267279. We can start off with the first graphics and just analyzing this. Tuone if you can have that on the screen. Yes, so that is section 45. It says, no person shall for any purpose take possession of or dispose this particular or otherwise intermeddle with any free property or of a deceased person. And last week when you're really trying to understand what the fact that we now, because you're saying at that time, now without, because this hasn't been passed into law.
It's still a bill.
Yes, so this bill hasn't passed. So up to this point, according to the Constitution, we do not have a meaning of intermeddle.
Yes.
Is it in the right direction now that if this bill proposed by Veronica Maina having a specific meaning of intermeddle, is that the right direction? Ama having a specific, it will tie the hands of the courts to this is what intermeddling is?
No, it's a step in the right direction. And even now, if someone is charged with intermeddling, the courts have not been silent or indolent into giving life to the provisions of the law. So what the court does, if there is no express provision, it tries to get definition that may be retrieved from the previous or other courts' decisions. So what we now have is a definition from the practice of court. But now, once this law is passed, we will have a definition from the Act, so that henceforth the court will be saying whatever you did is contrary to the definition provision on this section of the law. And therefore, anything that you will do will be measured kuangalia kupitia kile kipengele ambacho kinaelezea intermeddling ni nini. Lakini hata kwa sasa, kama vile ambavyo tulielezea pale mwanzo, pale mbele, makosa ya intermeddling, mahakama imejaribu kwa mapana na marefu kupeana ni kipi kitakachohusishwa katika makosa ya intermeddling. Kwa hivyo wewe sema umeponea. Kile kitu ambacho kitawezeshwa na sheria ambayo itapitishwa ni ku ensure that there is certainty, clarity and definitiveness in terms of what intermeddling is.
Right. So we can have the graphics back. Tuangalie part B of what hiyo number 2 inasema. Any person who contravenes the provisions of this section shall. So the first one, you've told us, be guilty of an offense and liable to a fine not exceeding 10,000 or a term of imprisonment not exceeding 1 year or both. I'm interested in part B. Be answerable to the rightful executor or administrator to the extent of the assets with which he has intermeddled after deducting any payments made in the due course of administration. So who is the rightful executor or administrator? In the context, tuweke context yenye uko na familia hapo. In familia baba, mama, watoto wawili for example. They're still underage, for example. And baba passes away. And so this is happening. So this family, hypothetical family, they're listening to us asubuhi. And the father of that house passed away last week. Kwa will alikuwa ameandika, for example, the mom is atachukua shamba yenye ako nayo. So is the mom the rightful executor, administrator? What does this mean?
Now what happens, there are two approaches to succession. Amba kuna njia mbili za kufuatilia mali ya marehemu. Kuna ile ya kwanza ambayo tunasema ni testate. This is where marehemu alikuwa ametengeneza kile kitu ambacho tunakiita will. Ya pili ni intestate. Marehemu alifariki pasipo kutengeneza will. In the testate succession, katika kutengeneza will, marehemu ama mwenda zake atakuwa amemteua yule mtu angetaka awajibike katika kuhakikisha kwamba mali imefuatiliwa hadi tamati ama hadi wakati ambapo kila mtu atapata kile kitu ambacho angetaka yule mtu akipate. Without that, then the property goes to intestate succession, where we are saying there is a hierarchy as to who can become the administrator. Remember, in the testate we talk about the executor, kwa sababu ni yule mtu ambaye atafuatilia yale matakwa ya mwenda zake. In the intestate, where there is no will, we talk about administrators. These are the people who are appointed by the court to administer. Yes, after going to court. Yes. Now, the law gives hierarchy of the people who can apply
to be administrators.
To be administrator.
Right.
One is the spouse. The others are the children. Then we have somebody we call the public trustee. And then we have the creditors. They may also apply. That is the hierarchy. What happens, kama pako na mtu ambaye katika ile orodha hayuko mwanzo wa orodha ama juu ya orodha, lakini angetaka kupewa nafasi ya kuadminister the property, they have to get the consent of the others who are above them. Or you demonstrate to the court that the people who have more powers to apply have not applied for the letters of administration. So
kama the dad passed away last week on
whichever date.
let's say on Thursday.
Yes.
Siku kama itu on Thursday. Out of all these people you've mentioned,
yes,
can they go to court immediately the following day on Friday and apply to be an administrator? In the sense that family might hawatataka kwenda immediately because of grieving and all that, but then creditor aone huyu mtu akona pesa yetu, wacha tukimbie court haraka tukue to file to be an administrator. Does that lock the spouse?
No. What happens if the administrator or if the person who is below the rank, the hierarchy, wants to apply, they have to get the leave of court. What happens, the person who is entitled to apply, if they do not apply, and the person who is below in terms of the hierarchy anataka kwenda mahakamani, atafile makaratasi ambayo tunaziita citation. Citation unawauliza mahakama imuulize ule mtu ambaye akona nafasi ya kuapply. Either apply ama mahakama ikuruhusu wewe uapply kama hawatakuwa na sababu ya mbona hawaja apply.
Oh, so even for this spouse, so kama the creditor lazima
yes, the creditor cannot get the letters without the knowledge or without the permission of the other persons in the hierarchy.
Okay.
The essence of that ni kuhakikisha kwamba watu ambao hawana nafasi, hawajatumia njia za mkato kujitajirisha na mali ya marehemu. So once the citations are filed, they will be served upon the person who is said to be higher in terms of the hierarchy. Yule mtu naye ataweka majibu. Majibu yake inaweza kuwa pengine tumekosa kwenda mahakamani kwa sababu hatujapata stakabadhi ambazo zitatuwezesha kwenda mahakamani.
Okay.
Ama atasema naomba mahakama inipe muda wa siku ambazo atazitaja ili aweze kwenda mahakamani apply for the letters of administration. So that is the essence of the hierarchy.
Right.
And then in terms of the number, the law allows a maximum of 4 individuals, watu 4
to be administrators.
Wanaweza kuwa administrators.
Before this person passed away, alikuwa na executor. Wenye umesema,
yes.
But title deed yake kwa shamba kuna mtu ameandika hapo kama executor.
Yes.
Immediately this person has died. Tulisema alikufa unfortunately last week on Thursday. Hypothetically, huyu executor immediately after the passing of friend yake, for example, akona right kukuwa administrator automatically, ama sasa lazima aende all the way kuanza kufile process ya kuwa administrator?
Kama kuna executor, ataenda kotini, atapewa kitu inaitwa letter of probate ili aruhusiwe kushughulikia mali ya marehemu kama mtu ambaye akona haki kisawa kushughulikia mali ya marehemu. Hata shughulika pasipo kwenda mahakamani na mahakama inampa ruhusa baada ya kumpa the letter of probate. Yule ambaye hakuwa kwa will, kama kwa will hakuwa ame-appoint somebody, we are calling the administrator, the persons entitled wataenda kotini wakuwe appointed kama administrator with the will or the administrators of the will. Kama hakuna will, atakuwa appointed administrator in the estate, intestate, kwa sababu hakuna will.
Okay. And that goes to answer what Njoki anauliza hapa WhatsApp. Yes. A family member insists on being administrator and then sits on property bila communication with beneficiaries. What is the remedy? Hiyo ni swali ya kwanza. Anza kuingia. You can also send in your question 0793267279. Tuko tunazisoma. So before you go on a short break at the top of the hour 9 AM, unaweza mjibu hii.
Yes.
For more clarity, to the break, turudi na maswali zingine.
If a family member is sitting on the property of the deceased without telling the others, they are intermeddling. Because you see, the definition of intermeddling, as much as there is some attempt to define it, inasema, or in any other manner dealing with the property. It can be anything you're doing, but you are dealing with the property of a deceased person without the authority or without the permission of the court. So kama yeye tu anaketi pale, anazuia wale watu ambao wako na nafasi kisheria kuchukua hatua ambazo ni mwafaka, pia yeye akona makosa ya intermeddling.
Okay.
Yes.
Right. Kabla tuchukue break, tuchukue simu ya Patrick kutoka hapa hivi Nairobi. Patrick, habari asubuhi. Najua Nairobi kuna baridi. Sijui unakunywa kahawa moto sahi?
Ya, nilikuwa naulizia.
Yes.
Mtu unataka kununua ploti kwa mtu. Na iko kwa allotment letter, iko kwa title deed. Then allotment letter inapia ni jina ya mama yake.
Okay.
Na mama yake alikuwa amekufa.
Okay.
So yeye ndiye amebaki ameiridi, lakini haiko kwa jina yake. So kuna hiyo tunaita transfer letter ndio upate title deed. Inaweza chukua how much kwa koti na inaweza chukua how long ndio hiyo transfer letter upate, na ni process gani utafuata ndio ipate.
Right. Asante sana for that. Nimeandika swali yako chini. Asante sana Patrick, and keep warm. I don't know, tuchukue break. Nimeandika hiyo.
Yes.
We are taking a short break right now. Keep on talking to us. Kuna zingine zinaendelea kuingia WhatsApp 0793267279. Tukiendelea kuchukua break, unaweza pigia watu wa nyumbani masimu waulize shida ni gani, wacha tuulizie hapo hivi live on TV47. Weka credit sai, then when you come back, throw them in. Wakili will be answering them for you. Intermeddling with the property of a deceased person, you'll have to pay 10,000 Kenya shillings as fine or go to jail for gathers 12 months. Nuepuke yoyote, make sure that all your questions have been cleared right here live. You're watching Morning Cafe, News to Standing in Rungita. Don't go too far.
Hey there friends, welcome to Kids on the Block, where fun and imagination come alive. We dive into magical world filled with exciting adventures and awesome friends.
What position were you in?
I was number 2.
What position were you?
Number 1.
He decided to cross the bridge by his house and look for food on the other side.
We're going to do half cup of chocolate chips, and the other one, we're going to do half cup of the blueberries.
So, grab your imagination hats and get ready to explore with us. Join us every Saturday at 9 a.m. for new friends, amazing stories, and tons of laughter.
Join us as we explore the journeys of those who defy the odds and break barriers. We dive deep into the stories of triumph.
Sometimes when parenting a child with a special need or whatever disability, family life becomes a bit complicated and you may end up raising the child on your own.
Here, we inspire.
I have a farm which one we showcase with other dyslexic youths and autism, how to farm.
Motivate.
It's never easy, but what we do, the best thing is to work with another parent who has an elder child than yours.
And break through the barriers one story at a time. Push your boundaries beyond the limit. Saturdays at 8 p.m.
Most definitely. This is Morning Cafe, and it's a Thursday. We're discussing law matters. Conversation for today is a part of what we had last week, but one, intermeddling with the property of a deceased. And Wakili is here. He's before the break, he was explaining to us what intermeddling is, what this constitution says, sections 45, 46, and other sections on Law of Succession Act. There's a question here by there's a caller before the break, in case you're just joining us. There's a caller, Patrick from Nairobi. Just to rephrase what he said, amenunua plot na hiyo plot iko na allotment letter, and it's under the mom's name who is deceased. So he wanted to know, I think, the cost, how long it takes, as well as the whole process. Wakili?
Yes, thank you. And in responding to this question, I would like to briefly take the viewer through the process of buying a property where the owner is dead. One, it is possible. You know, it's good to start with the positive. Inawezekana kununua shamba ambayo mumiliki wake amefariki. Lakini kuna vitu ambazo lazima uhakikishe zimefanyika. What has happened, if somebody is dead, before the process is finalized and the title becomes in the name of the buyer, lazima the process of succession ikuwe imekamilika. So that for the process of succession to be completed, the people who are going to court, they will get what we call the certificate of confirmation of a grant. This is the document ambayo inasema shamba W litapewa X. Shamba X litapewa Z, shamba Y litapewa B, so that when that is done, yule mtu ambaye kwa ile certificate amepewa, huyo ndiye mtu ambaye ako na uwezo wa kukuuzia lile shamba ambalo ni la marehemu. Pasipo lile kufanyika, yule ambaye atakayenunua lile shamba hatakuwa na uwezo wa kuliweka katika jina lake. It will not be possible to transfer that property. And what happens, we talk about transfer and transmission. Transfer, it is from a living person to a living person. Transmission, it is where the property is coming from a dead person to a living person. So, because the process of transmission mostly happens through the process of succession. That is where shamba linatoka kwa marehemu linamuendea yule mtu ambaye ameteuliwa kisheria ama ameteuliwa na marehemu kurithi lile shamba. So that once the transmission has happened, that is when the beneficiary can transfer the property now to you.
Okay. Kuna kola hold it up kidogo tu wakili before Jairus kutoka Vihiga kata simu. Jairus, bari asubuhi, welcome to TV47. Unaongea na Stanley Nyaringita. Uko na swali au maoni? Tafadhali paza sauti kidogo. I hope umemute TV. Hello, yes, karibu.
Jairus, we can hear you.
Mimi ni Jairus Amoni.
Yes, uliza. Punguza sauti ya TV tafadhali.
Sana.
Yes.
Mimi niko na swali. Halo.
Endelea.
Halo.
Endelea. Okay, tafadhali Jairus, if you're going to call back, have your TV mute or have it off, and that goes for everyone who's going to call us. 0795-045-864. It's going to very easy communication. Make sure si lazima ujisikie, by the way. Utupigie simu, have it mute, have it off. So before Jairus was calling us,
yes,
there's something you were explaining, but then I'd love even for the viewer kuelewa what property means, because hapa Kenya ukiambia mtu property, the first thing that goes to the mind ni shamba, ni land really, ama buildings and all that. Does the constitution, because even for the bill we're really seeing it defining what intermeddling is, Veronica Maina's bill trying to understand and help us understand what intermeddling is. Does the constitution define what property means in this case?
The property, when you're talking about property, we have anything that a person owns is their property. It may either be a fixed property or a movable property. When we are talking about fixed properties, we are talking about land, mostly land. When you're talking about movable property, we are talking about other properties. We have money in the bank, we have motor vehicles, we have other properties, and then we have the others. And when you are talking about movable or some, in other terms, they talk about tangible and intangible property. Like, for example, the intellectual property. Now in Kenya, you can have an intellectual property because a creation of your mind, it's your property.
So now, yeah.
Yes, so property is a very broad concept, and it is anything that someone can own, whether movable or immovable.
Right, we have Jackson from Narok, but then we'll be back to understanding what property is, because there are certain elements that I feel might be gaps there. But tuchukue simu ya Jackson kutoka Narok. Jackson, unazungumza na Stanley Nyaringita hapa TV47. I hope umemute TV yako ama iko off. Sijui kama kuna swali au maoni.
Halo, ni swali.
Yes.
Tulinunua shamba. Lakini baada ya kununua na mwenyewe akakatakata. Aya, sasa baadaye alitupatia duplicate ya title. Lakini baadaye akatuambia title imepotea.
Okay.
Sasa sisi ndio tutagharimia kutoa hiyo title kutoka kwa serikali.
Right.
Haya, sasa swali ni hili. Sisi ndio tulikuwa tunastahili kulipia hiyo title imepotea. Alafu
yes.
Shamba kulingana na title.
Yes.
Shamba ni kidogo.
Yes.
Lakini kulingana na ground.
Yes.
Shamba ni kubwa, ni eka 1.25. Sasa tutapata ukweli wetu namna gani, kwa sababu shamba ni kidogo kwa title. Na tukienda kwa wakili pesa zile tunalipishwa ni kama zile tulilipa. Ili tutafanya namna gani ili tupate ukweli wetu?
Okay. So, asante sana Jackson. Wacha wakili atakupatia jibu tu sahi from Narok there. Thank you very much. You've been scribbling his question.
Yes,
very well packaged question.
Yes.
You can even feel the even in his voice.
Yes.
This is something that imemuumiza sana yeye na watu wake, and this is it goes with anaongelelea Wakenya wengi sana this morning.
So one, I got the Jackson's question inaelezea kwamba walinunua shamba. Yule ambaye alikuwa anawauzia baadaye akawapatia photocopy of title, baadaye akawaambia the original imepotea. In the transfer of property hawezi pata a title document pasipo na original document. Kwa hivyo kila kitu anafaa waelewane, na kwa maoni yangu hii ni gharama ambaye yule mtu anawauzia ndiye anafaa kugharamia. Ile gharama ambayo pengine wanaweza kubaliana kugawana ni gharama ya kugawanyisha shamba. Tuseme kwa mfano shamba ilikuwa eka 5. Wao wananunua ekari 1. Ile gharama ya kugawanyisha wanaweza kubaliana jinsi ambavyo watakavyogawana. Kuna wengine wauzaji wengine wanakwambia gharama ya kugawanyisha itakuwa yangu, alafu wewe utalipia gharama ya kupata title ambayo itakuwa kwa jina lako. Japo title itakuwa imepotea, kwa maoni yangu gharama yafaa ikuwe ya ule mtu ambaye ameuza. Kwa sababu gani? Unamuuzia mtu kitu ambacho kinaeleweka. Haumuuzii shamba lote. Kwa hivyo we mwenyewe ni jukumu lako kuhakikisha kwamba kila kitu ambacho unakiuza ni kitu ambacho ni kipengee cha jumla, or it's a part of a whole. Unless you are selling the whole portion. Kwa hivyo in terms of what needs to happen, yafaa wakuwe na makubaliano. Whether it's the seller who will foot the bill for having the replacement of the title, inawezekana, or it is the buyer, or watagawana katikati.
Okay.
Ya pili, kama kuna tofauti, differences between what is contained on the title and what is contained on the physical ground, yafaa wamuite mtu anaitwa surveyor. Ukiangalia kwa title document, na our viewers have titles, inakuanga imeelezea the size.
Okay.
Inasema for example ngong stroke this parcel, that is the title. And then when you look at the title, there is a provision inasema either 0.057 hectare or 0. It will give the definition.
And both of them have to be the same. What is the title and on ground?
The title tells you what is on the ground. Tunapata aje the title? Surveyor anafanya mutation, anagawanyisha lile shamba. After amegawanyisha shamba, anahakikisha kwamba ile the size ambayo imegawanyishwa ndio size ambayo itatokea kwa sababu the size inapewa number. If we have one big piece of land, this one big piece of land, it has a number. After the subdivision, each subdivision will have a number. and that number will correspond to the size of that particular subdivision. So it is not possible to have a title inasema the size, lakini kwa ground kumaanisha then there is some discrepancy.
Altercations ilifanya kwa
kuna kitu ambacho si kweli. Ya pili, katika kununua lazima ujue unanunua which size. Kama unanunua 1 acre, inafaa kuwa 1 acre kwa map, kwa map, 1 acre kwa title na 1 acre kwa ground. So kama kuna difference, mtafute surveyor. Surveyor atakusaidia kujua for your land, beacon iko hapa, inatoka hapa, inafika pale, inatoka hapa, inafika pale. Na ukishapima utakutea kwamba your size ndio hii na ndio hii title inasema hivi.
So Jackson kutoka Narok, I hope umepata hiyo jibu vizuri. So back to what we were trying to really understand, and I mean as much as property, si shamba peke yake, there's so much venye umeelezea. And you're saying that it is property whatever belong to the deceased. So here's my question that a number of people would really even be concerned, because we've in the past have had conversations on small claims court. You have conversations around hapo kwa small claims court, something I think it's below 1 million.
Yes, we call it the pecuniary jurisdiction.
Yes.
Small claims court. It's 1 million.
Yes. Ndio nashangaa pecuniary matters that deal with money.
Ni hela ambayo idadi ya hela katika ile mahakama ni
less than $1 million.
Yes.
Is it possible to go to the small claims court for any property that the deceased had that belonging to you that is less than $1 million? And my question would really be, is there a specific amount yenye constitution imeweka yenye ikipita hii chini, this doesn't really mean that you're intermeddling with it?
Hata kama ni shilingi moja,
you're still intermeddling?
Yes. Hata kama ni shilingi 5, you're still intermeddling with it.
Okay.
There are 2 courts that have mandate to follow on the issue of succession. One, kitambo, it is only the High Court that will deal with the matters of succession. Lakini kwa sasa High Court inaruhusu kukiangalia ama sheria inaruhusu even magistrates courts ama hizi mahakama ambazo ziko chini ya High Court zina uwezo wa kutatua mambo ambayo yanaandamana na succession. In some instances unakuta yule mtu ambaye anaitwa public trustee, iwapo hela si nyingi, na pia public trustee anaweza public trustee, ofisi ya public trustee, hii ni ofisi ambayo iko katika ofisi za mkuu wa sheria. Kuna wale watu ambao wanawasaidia watu kama the value of the property it's not as much, but then at the discretion of the public trustee. So normally if the value of the property is above 20 million, you go directly to High Court. If it is below, you may find that people are going to the magistrates courts, and those courts have power and mandate. Zinashughulikia kesi hadi inafika tamati.
Okay. Yes. So there's a whole infographics on this section 46. We'll be taking a look at it in a few, section 46. But before that, we have a caller from Olu. Naambiwa ni Olu kutoka wapi? Trans Nzoia. Habari ya asubuhi Olu.
Ni Paulo.
Oh, Paulo. My apologies.
Kepoyo.
Yes, Paulo. Karibu sana to TV47.
Thank you. I have a question.
Yes.
I bought a land in 2008 from an administrator. And the person, the owner of the land died 1 year ago.
Okay.
And the same person sold the land 2009 to the second person.
Right.
And 2011 is sold to the third person again.
Okay.
My question is, what is my position in this land again?
Okay.
Yes.
Wakili, you've got the question?
Yes.
Sawa. Thank you very much, Paulo, kutoka Trans Nzoia. Kelly will be answering a question right now. 0795-045-864 is the number to call us. There are more questions coming in on WhatsApp. Keep them coming. We'll be making sure Kelly answers them. Let's get callers.
Now, Paul, my namesake, bought land in 2008, which land was also sold in 2009, and which land was also sold in 2011. Now, this person, the administrator, is in a scheme of selling something, or defrauding people with the intention to sell. Now, you can report this. But since Paul bought the first person, now when it comes to the title, the first registration is presumed to be the genuine registration.
Okay.
In the event Paul registered his property, or because once you buy, you cause for registration and the title becomes in your name.
Yeah.
So we need also to understand, after Paul bought, did he just buy or he followed up to have the land registered in his name? Because if that happened, then whatever was done in 2009 and 2011 is a nullity, because the land had already been sold and transferred to Paul. If not, if for example he just bought, paid money without following up on the registration, he can still enforce if there are documentation. Of course, in buying land you must have documentation. If there are documentation showing that indeed Paul was the bona fide purchaser as at then he can follow up, or even through the court, for two things. One, what we call the specific performance, that he bought the land and therefore the seller, who is the administrator, should be forced aeke shamba kwa jina la Paul. Iwapo hakuwa amefanya hivyo, na wale wengine walionunua wakakuja pia wakanunua wakalipa na wakakuwa wakawekwa majina the property was put in their name, still Paul has a claim. What you need to do, or to demonstrate even before the court, one, he bought, he paid consideration, and therefore the administrator was under a duty to perform their part and cause the transfer in favor of Paul. That being the case, then there is nothing that the person who bought in 2009 and 2011 bought. They bought something that was not in existence because it had already been bought by Paul.
All right.
And Paul has an action against the administrator.
All right. So on WhatsApp, if you granted, this is Modek asking, if you granted power of attorney and the person dies, when does the power expire?
So the power of attorney is not, this is the mandate to perform. When the person who gave you the powers is not there, that power you cannot perform with it.
Okay.
It's like an agency. If the agents, in an agent's relationship, we talk about the principal and the agent. The agent receives instruction from the principal. If the principal is not there, and the mandate they were to perform would require the principal to be there, then the principal has the agent has no mandate. Now, there are two types of power of attorneys. There is the specific power of attorney and there is a general power of attorney. It also depends with what specific assignment was to be done. Because if you are given a power of attorney to do something and you did, it is concluded. Then whether the donor they're known as the donor because they are donating the powers to you, whether they are alive or not, the mandate for the power of attorney has been performed. If it was a general power of attorney that you can undertake assignments on behalf of the deceased, when the deceased is not there, you do no longer have those powers.
Right.
Yes.
Kuna swali hapa, and this will help us with the infographics in section 46. So the question, this person is saying, that is Mazmuok, anasema, is a chief, okay, kidogo But let me just have it again. So is a chief authorized to hold documents of a deceased person against the wishes of the family members? And it is rightfully pale kwa section 46 highlighting duties, some of these responsibilities. Hold on, wacha tuchukue simu ya Kamwaro, yes. Kamwaro kutoka Narok. Kamwaro, habari asubuhi, watu wa Narok mnaendeleaje?
Hello, morning.
Good morning.
Yeah, I'm calling from Kirinyaga, eh?
Kirinyaga, yes.
Yes. I bought a piece of land,
Okay.
For 1 million.
Okay.
All the family members were in agreement that they sold the plot to me. The father was deceased. Then we wrote a letter through the chief and they included me as a family member.
Okay.
And it's there. We all signed and he gave our ID numbers.
All right.
And then the person who sold the person then went and got the limited grants and sued me in Keshogoro court. That I fraudulently acquired the plot, and she is the one who went to the county government and transferred the plot to me. So, and I built a house worth 5 million shillings. How do I go with the case now? Am I about to lose my property?
Okay.
There's a chief's letter indicating me as one of the family members so that I can protect my property. And I bought the plot for 1 million shillings. I've been paying rents.
All right.
And I've got the minutes from the county government stating the same. What are my rights, sir?
All right. Thank you, Kamara, for that. Salimia sana Kirinyaga. Okele will be answering that for you. Okele?
Yes. One, there are two types of grants that one can get. And I want the viewers to be very, very aware that a limited grant cannot be used to transfer land to you. A limited grant, I will repeat, a limited grant does not confer the holder of that grant powers to transfer land to any person. It is only a full grant that has been confirmed in something we said or we called certificate of confirmation of grant is issued, saying that this person has this property. So a limited grant, if you're buying a property and whoever is selling you has a limited grant, tell them to get a full grant.
Okay.
So if for example Kamwaro got or was sold the land by demonstration of a limited grant, his title to land can be challenged.
Right.
It doesn't matter how much he has invested. As per the law, the process under which it was followed was not a genuine process. What happens? Our courts are courts of law and courts of justice.
Right.
Court of equity and justice.
Right.
So they will try to balance so that as much as we are saying the title you got is not genuine, the court may say this person has been here, and I'm saying may. It's not what the court will say because the courts follow the law.
All right.
If the title was not obtained through the legal means, it is null and void.
Right.
It doesn't matter how much you've invested. That's why it's important to ensure that before you get the title or before a title is processed, follow through all the processes. And I've said a limited grant cannot confer title.
Right.
And I wish we'll get a chance to define what are the properties that can be inherited through the succession process, because there are some other properties that cannot.
Okay. Tuko na simu ya Ken kutoka Vihiga. Then there's still more other questions on Facebook. Ken, habari asubuhi, watu wa Vihiga mnaendeleaje?
Tunaendelea vizuri.
Okay, asante sana kwa calling us. Do you have a question, feedback?
Yeah, no, I have a concern. I have a question.
Yes.
In our family, I lost my brother.
Condolences.
Yeah, and this my brother happened that he had 3 kids. Yeah, now and the mom to the kids.
Okay.
They had separated with my brother.
Right.
Long time ago. around 15 years ago before he died.
Right.
Now, according to the records, because he was a teacher, the next of kin, he had indicated that my dad, my father, was the next of kin. So these his estates now.
Right.
Who is the rightful person now to follow? Is it my dad or the kids? Because also and at the same time, where does now the chief, the area chief comes in? Because now the area chief was lured and he was given some money by now the wife to my brother.
Right.
And he wrote a letter purporting that he had a family meeting. He wrote now to the widow. I mean to the wife, who was my wife to my brother. Yeah, purporting that we had a family meeting and we agreed that now she should be now the administrator of the property. I mean of the estate of my late brother.
Right.
So I'm asking, who is the rightful person in such a scenario to follow, and where is the chief coming in? Is it the rightful person now to interfere with the family matters?
All right. Thank you. Thank you for that question. Ken kutoka Vihiga, salimia sana watu Vihiga. Wakili is answering that for you. And Wakili, it's as if Ken picked that question, his final question, out of my mouth. It was something that I wanted to ask because I've heard the word chief a number of times. It was what I wanted to look at on the infographics here, section 46. Yes. We'll get to that when you analyze that. But let's first start, even before tuingie kwa chief, tuanze na, you've had his story. Who's the rightful owner on this?
Now, the law of succession defines the property that can succeed or that can successively be passed through the process of succession. What the property is defined is the free property. And the reason why I'm saying free property is because this is the property that is singularly and only written in the name of the deceased. Now, there are other properties or there are other forms of entitlement that individuals are required to submit the names. For example, there are schemes like insurance schemes. There are other pensions and other schemes where one may be required to provide the name of a beneficiary or somebody who will benefit. In essence, when you say somebody is your next of kin, that does not mean that person is the person rightfully nominated to benefit from that such a scheme. So we need to understand, when somebody dies, the law of succession provides any property belonging to them, that which forms the free property, it is the one that will be inherited. Now, when somebody provides, and there is a difference between the next of kin and the beneficiary or the nominees. And I give an example of an insurance scheme where, if for example is a life insurance or life assurance, you will give the people who stands to benefit in the event of your demise before the lapse of the duration, or yourself may benefit if the term elapses before your demise. So there are other types of such arrangements. For example, in SACCOs, in other organizations where the portion or such a scheme, one is required to provide the name of the person entitled to benefit from such a scheme in the event one dies. The next of kin, in the definition of a person who is the next of kin, this is a person, in the event something happens, this is a person that you may want to get in touch maybe for anything regarding the person who is dead. The law of succession has defined any free property that belongs to the deceased. The hierarchy is there
Okay.
as to who should benefit.
It is the same that you're
yes, that
spouse,
is hierarchy, yes.
So after spouse, what?
The children.
The children, and then?
Then we may have the other family members.
Okay.
So they come after the immediate family.
So if hakukuwa na will, is it upon now the court to determine the specific family members?
The specific family members are known. And that's why one of the vital documents that is required is the chief's letter.
Okay.
But the role of the chief is not to dictate how the property will be divided. The role of the chief is to tell, the chief is an officer of the government. He tells the court that these are the families of the deceased.
So I want us to critically examine this contextually. This will help us in infographics here, section 46, part 4, which says an assistant chief or administrative officer becoming aware that there is in his sublocation or area any free property of a deceased person, or that there are resident in his sublocation or area any persons appearing to have the greatest legitimate interest in his succession to or administration of the estate of a deceased person, but that no grant of representation in respect of that estate has yet been made, shall, at the request of any person who appears to have any legitimate interest in that estate, and without waiting for a report under this section, by forthwith take in respect of the property of persons, shall all such steps prescribed by section 2 yenye iko hapo juu. Hapo hiyo ni maneno nyingi na kizungu nyingi. Tuambie contextually, mtu vilikuwa tunasema someone passed away last week on let's say Thursday. Does this family straight go to this assistant chief? Is it the assistant chief? What's the first point of contact?
After death, of course, they are supposed to get the permit to bury, the burial permit. They then surrender the documentation of the deceased so that they get the death certificate. So at the point you are going to the chief will do a letter.
So, and just to add on that, yes. So does jurisdiction here matter? Because you told us that property doesn't have to be land.
Yes.
It could even be money in the bank. So if hii pesa iko kwa bank fulani hapa Nairobi, do you have to go to the chief around that location pali bank iko? Ama unaenda nyumbani pali mtu alizaliwa?
Mostly, there is no specific delineation as to which chief, but you go to the chief who understands the deceased, the other beneficiaries, and presumably know about the properties that the deceased had. What I have seen people do, they may elect. Maybe somebody had alikuwa na shamba huku town na alikuwa na shamba pia ushago, or out of town, or maybe in some other areas.
Yeah.
Depending on where the property, the magnitude of the property, ama pale ambapo kuna mali nyingi, ama pale ambapo familia inaishi, ama ule mtu ambaye anawajua vizuri. Hapo ndipo watu wataenda wapokee ile barua. Kama ni pale nyumbani, pale ushago, you go to the chief and then you tell the chief. And this chief you're telling, ni ule chief anakujua. That then, whatever you are telling, the chief can confirm. Okay? And what happens, most of the chiefs, they know the deceased, and they know even maybe the deceased had 2 wives. So the chief will tell you, kama unakuja tu kama bibi moja nakwambia, go and get the others.
Mwingine.
Yes.
Hold up kidogo. You maneno ya chief na assistant chief. Nataka kuelewa really, and so many callers. And one of the callers we have right now ni from Nyamira, a place where we've had a lot of cases when it comes to maneno ya land. Brian, habari asubuhi. You're talking to Stanley Nyiringita hapa TV47. Uko na swali, uko na feedback?
Niko na swali kwa wakili.
Yes.
Niko na shamba ambaye ilikuwa na wives wanne. Ambaye kwa sasa ilikuwa imefanywa succession in the year 2012.
Okay.
Lakini hii succession ambayo ilifanywa haikufanywa njia ambayo inayofaa.
Alright.
Nyumba mbili ambayo ni nyumba ya kwanza na nyumba ya pili iliachwa nje. Na hizi nyumba ndogo ambayo ni nyumba ya tatu na ya nne wakafanya the proud succession ambayo walisema ya kuwa mama wa nyumba ya nne ndiye the administrator. But in the event, wakati tulienda kufuata hiyo makaratasi ambayo walipetition in the court, tulipata ya kuwa administrator hakuweka thumbprint.
Okay.
There is no consent through beneficiaries. Unfortunately, in the year 2021, we revoked the grant because other confirmation haikuwa imefanywa.
Okay.
Therefore, tumepewa na mahakama ruhusa ya kufanya a fresh succession. Ambaye tulifanya even the people ambaye walikuwa kwa hiyo shamba ambaye walikuwa wameuziwa, they are for the 18 people ambaye wameuziwa. But fortunately the title deeds all of them cancelled. Na the number was reverted back to the owner who is the deceased. Kwa sasa hivi tumeprocess succession ambaye inaendelea in the court until yesterday.
Okay.
Tumeenda intermeddling case ambaye because tuligundua ya kwa the buyers they are coming with numerous application in the court to defend their interest.
Alright.
Na kulingana na the buyers they claim that they walinunua shamba. Na the other beneficiaries ambaye ni wa familia sasa wanasema ya kwamba wao work on the other side of the buyers kumtumia ya kuwa sasa yeye ni mnunuzi. Amenunua shamba kwa familia of which is the wife of the one of the beneficiary.
Right.
Sasa tumeendelea in the court. Application sao wamesieka kwa court, tumerespond. Fortunately we have moved to make the mid-ring application in the court ambayo tunaomba orders under section 45. Ambaye sasa tumekuja tumeambiwa tuandike submission. Na the buyers wamekuja na objection ambayo wanasema ya kuwa the appropriate court ambayo ni magistrate court haina mamlaka yeyote ya kupeana orders ya evictions ya kuondoa wanunuzi wa shamba.
Okay.
Sasa swali ni hii kwa wakili. Kesi iko kwa appropriate court. Na hii appropriate court tangu process ya succession iendelee haijawahi sema ya kuwa haina evidence yote ambaye ya kuwa hii mahakama haina jurisdiction. Sasa wakati hii mahakama peke yake haijasema ya kuwa haina jurisdiction. Na wao wenyewe wanasema ya kuwa wanunuzi wanasema ya kuwa hii mahakama haina jurisdiction. Kwa hivyo mahakama peke yake itaweza kutoa is orders intermeddling is the Land Environment Court.
Right.
But on the objections notice, hawajaweka bring evidence ambaye ni affidavit ambaye ina support the objection notice.
Okay.
And the other buyers lawyers wamesema ya kuwa hii mahakama iko na jurisdiction. Kwa hivyo kufika sasa hawajaweka ile kitu ambayo tunasema hawajasema ya kuwa submissions wao wanaandika. Kwa sasa hivi mawakili ambao wamepaki kotini ni wawili. Ambaye wanasema ya kuwa hii court wao hawakubaliani ya kuwa iko na jurisdiction. Kwa hivyo sasa ndio maana ninauliza wakili. We know the buyers hawafai kupinga beneficiaries because it is a mandate for beneficiaries to benefit from the estate of a deceased person. Na the buyers, they don't have locus to stand because they are outsider and they are intermediaries. They cannot gain and benefit interest from the deceased person because the mandate is that the deceased estate will be distributed equally to the owners who are the beneficiaries.
Right.
So that the beneficiary to decide whether they go to give the mandate to the buyers
all not.
Right. Thank you. Thank you, Brian.
Naomba wakili aweze kutusaidia hapo ya kuwa hii mahakama ambayo wanayepinga ya kuwa haina mamlaka. Sisi tumeenda na kipengele ya section 45 kwa sababu wao wenyewe kama wanunuzi hawajawahi pinga mahakama waseme ya kuwa hizi title deeds waliacquire njia ya sheria.
Sawa. So unataka kujua kama maneno ya jurisdiction and all that. Asante sana Brian kutoka Nyamira. Wakili, quite a loaded question. He brings in different kind of dynamics here. The deceased had 4 wives.
So what I note Brian to be saying, and one, their case is in court. So we cannot discuss the merits of a case that is in court here, because that is not allowed in law. What I would like to say, that once the court will make if it's good that he has said that they are in court, and the issue of intermeddling, the issue of being left out, the issue of revocation, it is in court. What happens? The succession court gives the grant and can revoke the grant. Okay? So once that is done, then the court that has jurisdiction to determine the question of entitlement for the land is the land court. So if the succession court revokes a grant and cancels the title, it becomes functors officio. It has revoked the grant and it has cancelled the title. So unless fresh grants are issued, the court has any power to deal with that case. So the persons who have gotten that judgment or those order, they now go to the appropriate court, which is the land court, to ensure that if the entitlement for this person was cancelled by the revocation of the grant, therefore they are not legally on the property.
Can you appeal following the decision of the land court, and you feel this doesn't really sit well with me? Can you appeal and move to a high court?
Anyone can appeal at any time.
Okay.
If, for example, the decision for revocation, you feel the court was not fair in deciding it, you can appeal. Whoever feels aggrieved by the decision that will be made by any court, they can appeal.
All right.
But what I'm saying is the succession court, once he has mentioned clearly that the court said or revoked the grant and directed that fresh grants be issued. So if there are other applications, they will be determined. But in essence, and for the purpose of the viewers, the succession court does not deal with the issues of entitlement to land.
Okay.
It deals with the issue of who is the beneficiary, or who is the person entitled by. If the court finds that the grant was not given in the proper manner, it will revoke the grant. Once that is revoked, it is done. Unless you want to appeal the decision of the court to revoke the grant. So, and it's good that Brian said they have advocates. Advocates will advise accordingly.
Right.
What we cannot do now, we cannot discuss the merit of their case in court, because we will be preempting what the judge will say, which is not allowed.
So I hope you've got that, Brian from Nyamira, and thank you for that call. There is a question here by Modek. Good morning. A land was owned by 5 brothers who were all deceased, survived by 1 sister. 2 of the late brothers sold a piece of the land, yet there is no evidence except occupation by the buyers. The sister processes the land and own it, then sell the whole land to a new buyer and transfer. So the first question, do the first buyers have saying? The second question, do any other person has voice on the land, like a distant cousin? And the third, can the new buyer now evacuate the first owners? We can first start with the first. Do the first buyers have a saying?
If the process, if, for example, the question says that they were brothers, sisters?
5 brothers,
yes,
survived by 1 sister. 2 of the late brothers sold, all the 5 brothers are deceased.
Yes.
Their sister, the older sister, is the one who's alive.
Yes.
And out of the 5 brothers, 2 of them sold a piece of the land, yet there's no evidence except occupation by the buyers.
So that is not a sale, it's just vitu za kienyeji.
Ile brotherly agreement ya weka hapa.
Yes. So a sale should be followed with a transfer. So the documentation should be showing that huyu jamaa aliuziwa shamba na amefanya marekebisho kwa ofisi ya shamba so that ni yeye mwenyeji. Pasipo that, then that guy is just staying on the land that does not belong to him.
So what happens now to this buyer? Because that's his first question. Do the first buyers have saying?
Now, they don't have say unless they demonstrate they acquire the land in the right process. The say in any property is demonstrated by the documentation you have. So if there are no documentation, how then can he say that he has a say? It doesn't matter how long he has lived there.
Wow. The second one, does any other person have a voice in the land, like a distant cousin?
They don't have any voice. The hierarchy we gave, if this sister has more powers in terms of the hierarchy, the other individuals, unless they prove to the court that they were dependents, that is when they can go to court asking for a provisions based on their dependency on the deceased.
The hook of his question really was, after the 2 of the late brothers sold this piece of land, yet there's no evidence. So the sister who remained processes the land and owns it, and then sells the whole land to a new buyer and transfer.
Now, I would like to know, what does it mean that she processes the land and it becomes hers? Did she do succession? Or how did she manage to? If the process she used to follow to get the land in her name is correct, then she is entitled. And upon proving that there was no any other beneficiary that ought to have benefited from that parcel, then whatever she did, if she followed the right step, it's okay. She can, if the property devolves to her, she can transfer or transmit it to any other person.
So hypothetically, she did the whole succession, because now that goes.
That is what I am presuming.
Where he's asking, can the new buyer now evacuate the first owners? So this new buyers who the sister has sold to.
I'm saying the process of buying land is not like buying a kangumu. You know, a kangumu, you may not need any evidence of having bought a kangumu. You have to have documentation. And if the new buyers have proper documentation, they have absolute right to evict the ule mjama mwingine mwenye hakuwa na chochote besides being on the land.
Right. Wakili, we have about 7 minutes to wrap it up. And I had promised, even for the viewers to understand the whole role of the chief here. Before I get your final thoughts. And ulikuwa umeanza kutuambia what the chief really does here. There's so much articulated on Section 46 of the Law Succession Act. But help us understand, ukienda, because I mean, unatuambia huyu chief lazima akuwa anajua properties za huyu mtu, akuwa anajua huyu deceased person vizuri. So this family of the deceased, so they go to the chief and what happens in this case? What kind of documents do they provide to the chief? What does the chief do in this case until all this succession goes through?
Now, when somebody dies, the individual, even as I wish you can also display that provision for 46.
The Law Succession Act, yeah, yes. 46, yeah.
The chief helps the court understand who are the rightful and bona fide beneficiaries of the deceased, ama wale watu ambao ni watu halali kumrithi marehemu. That is the role of the chief. Usually what happens, and I've seen this happen, at times the clients come to me, they tell me the chief has not given us letter. We do a letter directed to the chief, asking the chief to help these individuals. They get their letter and the letter is done. Some other time, you see that the chief has left an individual. You bring it to because the chief is told. The chief will get the names of the beneficiaries, including all the wives, and the ID numbers of the beneficiaries. So if you are going to report to the chief has the mandate to interrogate, to seek to know whether what you are saying is correct. If the deceased had 9 children, you cannot go and say he had 7 children. Whether a child is dead or alive, the chief should be told so that he indicate deceased. You do not only tell the chief that which you want to tell him, you tell him the truth or her the truth. What is the truth? Who are the rightful beneficiaries? If the deceased had 2 wives, you tell the chiefs the names of those wives, and the children, they will also be told to bring their IDs so that the chief will record.
Right.
If there is any person who is also interested in the land, you also tell the chief that, so that the chief will indicate.
Will indicate. A number of people would definitely now ask, what if mtu akuje baadaye aseme, kwanza unajuanga after mazishi ndio watu utokea hivyo, nasema huyu ni baba yangu pia. Let's pick this call all the way in Nyeri. Geoffrey, habari asubuhi. I hope watu wa Nyeri mko salama. You're speaking to Stanley. Ringita hapa TV47. Do you have a question or feedback? Hello, Geoffrey. Right, ni kama Geoffrey amepotea. So still on the whole, Chief, just to really finalize on that. So Chief, ni documents gani anafaa patiwe at this point, and then because also section 46 tells us notify the public trustee of the steps taken by him. So first off, shall forthwith report to the public trustee the death of the person concerned. Who is the public trustee in this case?
So we say the public trustee. This is an office in the Attorney General's chamber.
Okay.
At times, the public trustee may come in to help in adjudication of the cases for succession, where the chief may be of the view that this one is not of value to be taken through the process of succession. So the chief will advise. The public trustee is an office in the Attorney General's chamber that help in processing of the succession. And
So,
actually, when you look at the hierarchy, we mentioned the public trustee. You remember?
So that means when someone passes away, na alikuwa na shamba, you have to go to the AG's office.
Not really.
Kwa hiyo AG chamber. Utafute public trustee ama?
Not really. Some people elect to appoint their advocates to process the process of succession for them.
Okay.
Some people may opt to go to the public trustee, because a public trustee is an office, it's a government office, where you just go and you are helped. You may not be charged anything.
Okay.
Because that is a public office. That's why it's a public trustee. A trustee is somebody who is given the mandate to hold something in belief that watasaidia wale watu ambao wanafaa kusaidiwa.
All right.
I hope I am clear.
And that's in every, because I think one of the biggest concerns that viewers have, and the public has when it comes to government institutions is, first of all, is it located where I am closely? Will I walk in and, well, you tell us the cost, it's free. Also, like, what kind of documents am I providing to the public trustee?
So succession process, whether done by a private advocate or a public trustee, you need to provide the documentation of title, entitlement for the deceased. For example, if he had a property, you need to provide the titles. You may also need to do the search for that property. You need to provide the chief's letter.
Okay.
And also, you also provide the death certificate.
Right.
And the chief's letter, this is at times, even in the chief's letter, the beneficiary may appoint that we want person A, X, Z to be the administrators. or they may leave it open.
Okay.
Yes.
So your final words in just a takeaway home for someone who's been listening to us for the past 1 and 30 minutes. Something that they need to know this morning, very, very briefly, and your contacts. After this conversation,
yes,
they can reach you.
What maybe my final word in terms of the succession, do not walk in uncertainty. More so in buying a property that may have belonged to a deceased person.
Yeah, yeah.
Because you may be sold a property by the person who is not properly qualified to sell to you, or the person may be involved in fraudulent activities. So seek the advice of a professional.
Right.
You can get a map from a surveyor or Survey of Kenya. You can get a surveyor. You can go to an advocate.
Okay.
Get advice. Do not just be quick to give money because you see the land.
Right.
Seeing the land is not enough. Have the land processed. Yes. And allow me to wish my wife Eunice a happy birthday.
Oh, okay. Happy birthday to us.
Yes.
Contact?
Yes. My phone number is 0704 259 082. Our offices are located at Bruce House, 8th floor, Suite 804. Sharia Gaido and Morigo Advocates.
Thank you very much for sticking around. This has been Morning Cafe. I'm used to Lee Stanley Nyiringi to do this every single Thursday. Matters law. Angalia maneno ya Law of Succession Act. Utasoma hiyo yote hapo. Have yourself a fantastic Junior Friday. Tuonane kesho.